Hello, and welcome to this week's Ask an Atheist. My name is Liz Cavell. I'm Associate Counsel for the Freedom from Religion Foundation. On Friday, the Supreme Court issued a decision in favor of a business owner who challenged an anti-discrimination law because she claimed a right to discriminate based on her religion. We will break down the decision for you and share our reactions to what we are euphemistically calling a hot mess. I'm joined today by attorney Kat Grant, who has a fellowship at FFRF through Equal Justice Works, and we are both joined remotely by FFRF's senior counsel, Patrick Elliott. And as always, if you have questions about this topic, you can drop them in the comments below, or you can send an email to askanatheist@ffrf.org. Patrick, before we get into the opinions by the Supreme Court on Friday, can you just give our viewers some background on the lawsuit?
Yeah, so this is the big Supreme Court decision coming down on, just this past week. It's the follow-up to the Masterpiece Cake Shop case. So a lot of people are familiar with that. A Colorado baker who wanted to discriminate against a gay couple and challenged that and went all the way to the Supreme Court in 2018. This has a lot of similar features. This is a Colorado business owner who wants to discriminate against gay and lesbian couples. So the business is 303 Creative, and the owner is Lori Smith. She designs websites. And so she has a small business in Littleton, Colorado, and hasn't actually received a request to design wedding websites and hasn't actually entered the business of wedding website design, but says she wants to. And she wants to not provide those services to gay, lesbian couples who are getting married. She has a disclaimer she wants to put on the website saying basically, she believes in biblical marriage, which in her view is, a marriage between one man and one woman, and she won't, provide these services to same-sex couples. That's what she wants to do. This is kind of a hypothetical case because we don't have an actual couple that was denied service like we had with the Masterpiece Cake Shop decision. And so why that kind of comes into play is it explains, a little bit of how the court got where it ended up getting. So she sues the Colorado officials saying, preemptively, the Colorado anti-discrimination law can't be applied against her, which pretty broadly says you have to provide services and goods, to people within a protected classes, which includes sexual orientation. So she wants to block that, and she also wants to say, I get to put up the disclaimer on my website. She loses below at the district court. She loses at the 10th Circuit Court of Appeals and goes all the way to the Supreme Court. And so that's the case that reached the Supreme Court, just last week.
Right. So it was probably the three of us a few months back who did an Ask an Atheist on oral arguments in this case, and we talked about what the justices were kind of previewing, the questions they were asking. If anybody remembers, it was like a funhouse, crazy show of like hypothetical scenarios, and all kind of trying to get at the hypothetical scenario at issue, which is this case. Because again, we don't have an actual act of enforcement against Lori Smith. There's nothing that she offers or holds herself out as offering that has been flagged for enforcement by Colorado. This is purely a pre-enforcement challenge going all the way to the Supreme Court on this issue that has been brewing in the religious right legal movement, which is trying to get exemptions from civil rights laws for business owners that want to discriminate against LGBTQ customers in the marketplace. So this case was held by the Supreme Court until the very last day of term, which was Friday. So they went out with a bang before the holiday weekend. It was decided 6-3 in favor of 303 Creative and Lori Smith, the business owner wanting to discriminate. So we have not had a ton of time to digest the decision. This was Friday, and we had a holiday weekend of, just trying to unplug from the world. But we all have some takes. We've all read the decision. We've all sort of processed the decision a little bit amongst ourselves. So let's first, Pat, share how the court reached its decision, and then we'll give our takes.
Yeah, and actually it's for a Supreme Court decision, it wasn't particularly long in terms of the 6 justices. So Justice Gorsuch wrote for the majority, but finding for 303 Creative. He, starts off his opinion kind of with lip service to anti-discrimination laws. He says, laws along these lines have done much to secure the civil rights of all Americans. But in this particular case, Colorado does not just seek to ensure the sale of goods or services on equal terms. It seeks to use its law to compel an individual to create speech she does not believe. So he's just, laying out what the majority thinks in terms of compelled speech. And so that's something the Supreme Court has ruled in other cases, that they can't do. The government can't force you to say particular things. Obviously, I have a different take on how Justice Gorsuch is addressing this, but I thought it was interesting, kind of his lip service to, I'm saying this, why I picked that quote is, he's kind of giving lip service to anti-discrimination laws. Because if you read what Justice Gorsuch writes, or if you even hear him talk, he acts as if he's the most gentle, like, oh, there's some good points here and there's some good points there. And I really like that there's this history of, anti-discrimination laws. It just so happens I have to rule in favor of this business owner. And so I think it's not disingenuous, but it feels really fake. I don't know if that kind of, we haven't discussed the case yet, but, I kind of felt that in his opening. That's his very first paragraph of the decision, is saying, I have to rule this way because of the First Amendment. If only I could, talk about the history of our civil rights laws and how we protect from places of public accommodation discriminating. So I don't know, that was kind of my off the bat annoyance, I think, with how the majority was addressing this. And I don't know if either of you reacted to that either.
Totally. It's like the first 20 words of the opinion, so it was off to a very annoying start. But totally, I think it's like the obligatory thing that one must say before eviscerating the civil rights of minorities, which is, we all can agree civil rights laws have done some good, much good.
Yeah.
Some might say enough good. Yeah. But unfortunately, Colorado just wants to secure too much rights for its gay and lesbian citizens. So it was super annoying and totally disingenuous, because this whole case, and we'll get into it, and Pat, you can go on with some of the the bases for the analysis, but the whole opinion is balance, the court's job here is to balance the interests and say, okay, maybe there's some kind of speech interest, and we can differ on every one of these micro points, and we do. But there is some sort of interest in total freedom of activity for this business owner, right? She wants to do things her way. 100%. And by being a business owner, you don't get 100%. You're organized under the laws of the state of Colorado, and you have to follow all these regulations and file annoying forms and register your business and follow some laws. And there's food safety if you're in food service.
How dare there be regulations?
Exactly. So there are competing interests, and the interest in civil rights laws that operate uniformly to secure the civil rights of the people, the protected classes that the state of Colorado has every right to protect. That is a really strong interest that is being given lip service in 10 words by Gorsuch before completely moving past it and giving it no weight whatsoever in the balancing of interests in this opinion. And that is infuriating, but is a key feature, I think, of this opinion, which is how little weight or even discussion is given to the purpose and the history of civil rights laws and anti-discrimination laws in this country. Why we fought so hard to have them be a part of our legal landscape in the past, and the purposes that they serve, and the weight of those interests and how important they are. That was one of many really, really infuriating features of this opinion.
Yeah, and I think...
Go ahead.
I was just going to say, and I think he spends so much time focusing on, the Civil Rights Act, civil rights laws, anti-discrimination laws, they've done some good, they've done a lot of good, et cetera, to try and distract people from the fact that, A, not only was this case completely and utterly manufactured,
right,
but also it was completely and utterly manufactured for him and for Justice Thomas. He and Justice Thomas wrote an opinion in Masterpiece Cake Shop saying, well, now wait a minute. Okay, so maybe the religious exercise argument isn't great, but Jack Phelps certainly should have won on free speech. And now here we are several years later going, oh, actually, here's a free speech case, an ADF completely designed this case to get to that point. As we've mentioned, there has never been a wedding website made. There was like in the middle, like I think maybe like right after the case was filed, but like during, all of the proceedings, apparently someone sent, a request asking for stuff for a same-sex wedding that might stretch to a website. And we now know, because people have contacted the guy listed on the complaint, that he never sent that. In fact, he is married to a woman and has been married to a woman for several years and also is a website designer.
Right.
So it is so clear that everything here was manufactured to a tailor-made court for Christian nationalists.
Yes, 100%.
And I think there is so much trying to, distract from the fact that this is not even like slow-pitch Little League. This is T-ball.
Yeah.
This is a T-ball case to gut civil rights protections for queer folks.
Yes, very choreographed. If you follow anything related to these Christian nationalist litigation groups that are just in full league with the ultra-conservative justices, like the Alliance Defending Freedom, who are behind this case, First Liberty, who were behind the case Patrick and I talked about last week, Groff. They are completely choreographing these cases to reach the court, to reach these results, to change the landscape in this way.
Right, Kat, I'm glad you brought that up because I was watching the news coverage recently, and the fake request that came in is getting a lot of coverage, but not the really bad opinion. And one interesting thing about the fake request is it was so obvious to me that it was fake. It's the court, the record goes to the Supreme Court. So when we filed an amicus brief last year and kind of pointed out saying, hey, this is not a case. This is not a real case. Like this, there wasn't a denial of service to particular individuals. This is somebody suing preemptively to say, aha, I can't be forced to do this thing that's never been requested of me to do. And so in the district court, the Alliance Defending Freedom had to defend the idea that this was not speculative. And they said, oh, look, we got this request. And actually, I think they filed it and wrote about it again before the Supreme Court. Well, when you look at it, it's like, this is not a real thing. So I emailed the guy. I tried to call last year, and nobody responded to either of these things because it was so obvious that it wasn't actually a real request. We did point out in our brief that this request came in on the same day that the Denver Post published that this lawsuit was filed. So it's like, obviously, either a troll or somebody kind of testing the website designer. There's not just a coincidence that they got a request for potentially, a website that where two men were getting married or male names were getting married. So anyway, that whole thing was like big in the news coverage, and people may have seen. I don't think it factored into the opinions here very much because the court just kind of glossed over the idea that this might not be, a ripe case or a real case. It's just let's rule on the issue. And I think, getting back to the opinion, one of the problems was, and I think maybe you all recognize this too, it's like the stipulated record. So the state of Colorado, in suing this, tried to do this kind of efficiently. And so they didn't challenge every factual statement that was made by the website designer. And some of those proved to probably be fatal because the idea that what this business owner would, when she would provide services and wouldn't provide services, was kind of all just agreed to by the parties and not really tested via, like a deposition or a trial or anything like that. So we're kind of left with the idea that the court, and this is why the majority opinion is kind of hard for us to put many further quotes up for the audience, is it's kind of circular. It basically says, hey, they stipulated that the websites that she does are her expression.
Yeah.
And why that's a little odd is like if you've ever been to everybody now has like if you've been to weddings, like usually there's a basic wedding website that's like, here's where you go, here's the time, here's a gift registry. They're off the shelf usually products, like you can go on the knot.com or the big wedding vendors. You can either sign up for free or pay a small fee and get a website that you can customize. Like people aren't hiring a web designer to be like, I need my custom website. This isn't like a real thing. But in the court size, it's not that it's very, very rare anyway.
Right.
It's not the same as like a baker baking a wedding cake. Everybody can understand that. You've been to a wedding where that happened, but you probably don't know somebody who went out and like shelled out, I don't know, $1,000 to have somebody design a custom website. You don't need that when you can kind of plug in your information on various other outlets to do it. So anyway, that all comes into play because this is why I think the opinion is hard to reach because it's circular. It basically says this is pure speech, and we're saying that the website owner is the communicator here and not the couple, which is what most people would probably think if you went to a couple's wedding website. You think, oh, this is their message, not the owner of the design company that put it together. So that's kind of a little bit of background in terms of like how Gorsuch got where he did. He says it's pure speech, and basically then says the state's compelling her to communicate a message. And this is in the conclusion. The First Amendment envisions the United States as a rich and complex place where all persons are free to think and speak as they wish, not as the government demands. Because Colorado seeks to deny that promise, the judgment is reversed. So that's the best I can do for the summary of the, of the majority opinion, because a lot of it kind of gets back to the facts that were stipulated, and then his assumption about this being some kind of message of the website owner and her communications, even though the state doesn't say, what message she must communicate, that she has to even enter this area of business. There's certainly questions of more so like conduct here with her denying service to people rather than her communicating a message. The opinion to be very circular in that way, and I don't know if you all had other points to bring up, but there's not as much to digest, and just that he looks at it from a very different perspective than I think we do.
Yeah. So I have a couple of things I want to just throw out there and see what you all think. So one, it's like noteworthy, especially for our purposes, that the majority opinion rested its analysis pretty much completely on free speech, the free speech rights of Lori Smith. And even though they're like inextricably bound up with her, deeply held religious beliefs, I was expecting a little more of like this doubly protected rights kind of analysis. And Patrick, I'm curious what you think about this. Like, they didn't really do a lot to say that like this speech is special because it's religiously motivated, which they have said in past cases. They just focused in more on how purely expressive website design is as, a mode of business. Like, just the fact that like website design is so purely speech that we're just gonna like proceed as though this is just compelled speech and we don't even need to reach the religiosity or the religious motivation of the speech. And it's not, it's almost, I don't know how I feel about it, like if it's broader or if it's better for our purposes. But I just thought it was notable because I expected a little bit more of the like religiously motivated speech gets even heightened protection under the First Amendment because it's doubly protected by both the free speech and the religion clauses of the First Amendment. And we didn't really see that. And I'm wondering if anybody else had thoughts on that, or whether that makes it broader or makes it narrower, or what you think.
Yeah, I think it cuts both ways, like you're pointing out, because they do say, this is the bad news, is they say it doesn't matter what your motivation is. Like, you could be a hateful person and say, I hate this group, therefore I'm not doing the service. And the Supreme Court would say, you have the free speech right to do that. In fact, I think some of the language they quote says, like, we're not going to delve into whether it's worthy of whether it's like a worthy belief or appropriate. So that's the danger in it being a free speech case, right? This could apply to really bad things. And it is applying to really bad things, but it's saying it's broad. I mean, it hits all protected classes. So like anti-Semitism, race, like it could be, you could deny service. Her website could deny service on those bases besides just like, oh, I have a particular view about marriage. And so I'm not downplaying it, but I'm saying the breadth is wide that way. But the good news, I guess, from our perspective is the court doesn't come out and say, well, we're going to allow religious people to get this special right that other people don't have. It just so happens that it's religious people who are the ones like wielding it against everyone else. That's the problem. But At least it's not like other people don't have that risk. So yeah, I think it's savvy to pick up on that. But he's actually saying like we're not going to say that her beliefs are good or worthy or somehow something that
decent
she
and
should
honorable.
be doing. Right.
As we so often do.
I think, though, that maybe on the other hand, I think we can all agree the court is a little bit out of touch to say it gently. And I think maybe, I know you and I have talked about all throughout decision season that like they have been throwing out, I'm going to say loosely, good decisions to try and rebuild their integrity and the public's trust. And part of me wonders if, they're sitting there, they know that this is Christian nationalist strategery and shenaniganery. They know. So by maybe not explicitly mentioning the religiousness of all of it, that they're trying to
totally
be sneaky, and in their minds they're thinking, haha, you can't say that we're privileging religious people because we never said we did, because they think that the American public
And this is free speech, which
read.
people, has a broader appeal than like our Christian nationalist agenda. I think that's right. And I also so kind of a follow-up to that, which I just wanted to riff on Patrick's point about the stipulated facts. I almost feel like part of the obsessive focus on the stipulated facts as this gotcha thing where it's well, the parties agreed that creating a website to sell to a third-party couple is the expression of the website designer, which is by no means a settled fact. It's disputed wildly amongst anybody that has anything to say about this case. But like Patrick said, it was stipulated to early on in the litigation by both parties where Colorado maybe didn't necessarily envision this being a Supreme Court case. So, and I think that was also a way of the court sort of not having to take ownership of factual findings, right? It wasn't, the court didn't have to say, we find that these websites are the expressive activity of the person creating them, not the couple whose love story is featured all over every page. It wasn't the court making that factual finding. It was the parties agreeing on those facts. And so it sort of allowed the court to say, this is also, we don't have to make any factual findings that would apply in other contexts, or nobody needs to read into what other, industries or businesses might be expressive or pure speech. We're just making legal findings based on the facts that the parties agreed to. We're not making factual findings. And I thought that was also a way of them sort of washing the opinion in a way that looks more narrow or less radical than it really is.
Just making it look more reasonable.
Yeah. I don't know. Because that's unusual, the focus on stipulated facts and just the pointing, he was making a point that these are not my factual findings.
Yeah.
I thought. Pat?
Yeah, and if you listen to the, we all discussed this on this show previously, the oral arguments, and it was getting at that point, who is communicating and what's speech and what's not, and when can I say no? And I think that's right. That's kind of how the court dodged it. The other thing I want to bring up from the majority, though, is Justice Gorsuch does say, which is good, but we don't know its limits, basically says, look, most things that businesses sell, goods and services, are covered by the anti-discrimination laws because they're not going to have that expressive element or the pure speech element. You can say that in the words there, but we don't know, obviously, where's the line drawing. I think this ties into your point, Liz. Where's the line drawing for when does the communication by a business on behalf of somebody else create that pure speech? So that's in the opinion. So I don't think people should walk away and think, oh, I can just deny selling, deny selling actual products to somebody because of who they are. That's still prohibited under the Colorado law and under probably all states' laws. It's just they're creating this carve out for expressive activity of some sort. We just don't have an answer on what will the limit of that be. And we know that groups like ADF, the Alliance Defending Freedom, who took this case, and others are going to push it. They're going to expand. This isn't ending at weddings. There's no way. This is going to be brought into other forms of expression. I don't know what they're going to do with it yet, but that's probably what's going to happen.
Well, considering they can apparently just make up whatever scenarios and facts they want to get whatever result they want, I think it's really impossible to know what they are going to aim for next, because I think this is also a broader, we're seeing this kind of train of the actual facts don't matter. We saw it with Kennedy, we're seeing it here, and it's just going to continue.
Right. Well, And I think, like, I have so many thoughts going on in different directions. But to your point, you're so right, because it's like, it's not like you could just look at what's factually happening and predict, like, oh, that's going to make it, that little controversy is going to somehow have to work itself out in the courts. Like, I feel like I read a quote Secretary Pete Buttigieg said, like, of this decision, like, this is a solution in search of a problem, which it is. It's like, there are just not states enforcing these laws against, like, religious business owners. Like, this website situation didn't happen. It's probably never would have happened, as for so many reasons. Like Patrick pointed out, nobody hires a graphic designer to make their not.com wedding website. Like, that doesn't happen. Also, it's a very open question whether CADA, the statute, would have been enforced against her, even if the scenario played out for real the way that she claimed it will or would. So, I mean, there's so many open factual questions, and this kind of thing is not necessarily going to happen organically. All the more, like, alarming that the court is seeking to choreograph these cases so that it can make these gutting of our decades of civil rights laws. But one other thing before we turn to questions, or if you all have anything else, I wanted to note from the majority opinion, and you kind of touched on it with regard to the businesses that it implicates, Patrick, but I just want to point out another thing I was a little bit surprised by. There wasn't a limiting principle in the case in terms of whether this free speech constitutional argument for basically exemption from these laws, whether it is in some artificial way limited to sexual orientation as a protected class. And I was surprised by that because, as I talked about in our oral arguments episode, and anywhere you've heard me scream about this, they openly, so by they I mean conservative justices and ADF lawyers at oral argument, when they're asked the hard questions at oral argument, like, well, how does your argument not apply to a business owner that wants to racially discriminate in this same, all the facts being the same, but the discrimination and the religious belief is interracial marriage is not biblically true. And lawyers for ADF basically say, like, it's not limited in that way. Like, this analysis, our argument would apply equally if that were the belief and the speech. And justices often, as you've heard me say, like to say that, like, we as a society have, like, rejected racist bigotry and racist discrimination, but we haven't yet reached that point of consensus around, like, sexual orientation discrimination. And so therefore, like, decent and honorable people hold differing views on whether it's okay to discriminate on the basis of sexual orientation. And so therefore, like, there's just a difference in the quality of discrimination between those two classes in terms of the interest. And I was expecting something like that in this opinion, and you got none of that limiting principle. So it truly does apply the way ADF kind of described in oral arguments. Like, this opinion, there's no reason in the opinion that you might think, oh, but this wouldn't apply in race discrimination. Like, this would apply in any class protected under Colorado's anti-discrimination status, race, ethnicity, religion, and sexual orientation and sex. This analysis would apply equally, no matter if you change that factor. And I was surprised by that, but it's worth saying that there is nothing in the opinion that limits it in any way to that.
Yeah, and I think that really speaks to, again, the strategery happening here from ADF and these, conservative Christian nationalist outfits that, like, they are targeting queer communities, they are targeting, gay people, trans people, because there isn't this consensus that the court wants. It's very much a boiling the frog situation, right, where, our rights are going to be dismantled, but then they're going to come for everybody else. And I think that is a big point that a lot of people miss. They look at just this case and they're like, we'll just go somewhere else. Why would you want to patronize this business anyway? And that is not the issue. I think that was, like, one of my very first reactions. So the issue is not that, LGBT people might not be able to access any singular business. It's that our rights are being made subservient to religious belief over and over again. And it's keeping the door open for all other marginalized communities, all other rights to be made subservient to religious belief. This supermajority on the court has made it very clear with this case that whether they say, oh, it's religious speech and therefore it's more important or not, that is what they are valuing over, a basic human dignity and the ability to not have to experience the shame of being turned away from a business that is open to the public. They very specifically picked wedding websites because LGBT people are the only people trying to get same-sex wedding websites.
Right.
So you can't divorce that product from the identity.
Right. Exactly. It's it's one of a category of goods and services that readily identify this particular protected characteristic of a patron, right? Like, you don't necessarily know if a person's gay by the way they order their burger. Don't come at me with takes on that.
I mean, I could have a take.
But you do know, reasonably, certainly, the identity of, the sexual orientation of a patron based on what they're ordering if you are a wedding vendor. And so that's why we are seeing, all these cases are coming up in the wedding context, because that is where the patron's identity and the good and service are so inextricably intertwined that you can't separate them. And they take advantage of that conflation by taking these cases and acting like it's kind of confusing, but it's, it's not the identity of the patron, it's just that I don't want to sell this particular good. And it's those things are completely intertwined.
The idea that I think got brought up in the dissent was, but if a gay person wanted to buy a wedding website for their straight friends, they could do that. And that's not how any of this works.
Right. Yeah. Oh, good. Well, that's actually...
This leads to let's talk about the dissent if we can, because I feel like Justice Sotomayor hits it spot on, is how, we've talked about this since 2018 when we were filing a brief in the Masterpiece Cake Shop case. I think this is the correct take on this whole body of how do we discriminate against, LGBTQ people in weddings. And she gets it, and she does kind of a masterclass, I think, in explaining where we are. So Kat, if you want to, take over on the dissent, I think it was great.
Yeah, so Sotomayor calls the majority opinion profoundly wrong, which it is. And she says, the law in question targets conduct, not speech, for regulation, and the act of discrimination has never constituted protected expression under the First Amendment. Sotomayor writes, and you can see it there on the screen, today the court, for the first time in its history, grants a business open to the public a constitutional right to refuse to serve members of a protected class. The dissent also highlights the fight for LGBTQIA plus equality that the country is facing. I discussed this a little bit earlier, and it's, discussed in the opinion. It recounts the backlash connecting it to the civil rights movement. On the screen we have there, and it's a long quote, but I'm going to read it because it's important. Around the country, there has been a backlash to the movement for liberty and equality for gender and sexual minorities. New forms of inclusion have been met with reactionary exclusion. This is heartbreaking. Sadly, it is also familiar. When the civil rights and women's rights movements sought equality in public life, some public establishments refused. Some even claimed, based on sincere religious beliefs, constitutional rights to discriminate. The brave justices who once sat on this court decisively rejected those claims. And frankly, that quote could have been taken directly from my project application for this fellowship, where I outright said, every single time LGBT folks get new rights, this conservative religious movement is like, no, I get to discriminate against you. My rights are more important. So I think that really gets to the truth of the matter, and I think that really hit home why this case matters, and that it is not just about weddings. I could yell about how it is not just about weddings forever.
And it's not just about, like you said before, access to goods and services, right? It's about it, because we're not just talking about what's available in the public marketplace. We're talking about, do we tolerate, what is the effect on society writ large when we tolerate refusals of service on the basis of protected classes, like the act of discrimination, letting that be a part of our marketplace, like it degrades a huge segment of our population, and like it's not about access, it's not about whether or not they can access those goods elsewhere. It's about like, do we tolerate that harm that in our marketplace? Like, is that interest worth something more than knowing that our public marketplaces actually promote like pluralism and like diversity and even religious liberty in the true sense? Like that is not a factor in the public marketplace, that you can't discriminate and be open to the public for goods and services. Like, you can discriminate all the live long day in your private life, but if you want to be a business open to the public, organized under the laws of whatever state you live in, like, you have to abide by those laws. And those laws are allowed to protect this crucial interest of making sure that we don't allow like certain minorities in our society to live like lives of indignity. Like, that's just a valuable state interest. And I don't understand why we're pretending that like we don't remember or understand what civil rights laws were about.
And I think the dissent does a very good job of going into what this harm is actually like. You know, one thing that stuck out to me was the example of a same-sex couple and their child going to access a service, and not only their parents being rejected, but their child having to look and be like, oh, my parents' relationship under the law is less than. It's not valued. They are second-class citizens. And the idea of up that way. And then also the way that the dissent discussed what it is like to walk around and exist as an LGBT person and not know whether it is safe to just exist, just to simply flat out exist on the same level as cisgender heterosexual people. And I think really focusing in on what do we as a society tolerate? Are we really prepared to say that some people are second-class citizens? And that is what this decision is saying.
Yes, it is. And I love that like well-warranted burn about like the brave justices that used to sit here rejected those claims and ...
Yeah, even just the what a difference 5 years makes
exactly.
quote.
And I think it's important, something else important about the dissent is also reminding the country and apparently the majority that like there's nothing new in what's being argued here or what's being asked for. The only difference is the radical like bent of the current majority, and like the fact that this particular court majority was open to these arguments for the first time in history, because like even the whole idea about speech and expression like was argued in the civil rights era as all of these anti-desegregation forces were working to protect their right to keep discriminating in the public marketplace. A lot of it was religious-based arguments, like I have a religious right to deny service to or to insist on segregated services to customers. But they understood then, they were savvy enough to say, like, maybe we can argue there's a speech component. And like there were plenty of arguments in the civil rights era by would-be discriminators that being forced by anti-discrimination laws to serve people of color on the same basis as white people violated their right to free expression, to free association, made them a part of the desegregation project in a way that violated their beliefs and what they wanted to express with their business. And always the court rejected that as what it is, which is just a smokescreen for saying, like, we want the act of discrimination to be protected and to be allowed. And for state laws and civil and federal laws saying, no, it's not.
Just to chime in on the one other, I guess, emotional example for me to read, because you're getting into both the law, but then also kind of the practical effects. And I think the dissent discusses a real example of, and there's a case about it apparently, of somebody, an elderly gay man died, and they had a funeral set up at a funeral home. And once the funeral home found out that that was the case, they canceled it. So basically, the family is then left. Obviously, this is a thing you can't, plan out way in advance. I mean, if it happened kind of suddenly, and I think that is a really emotional experience for the husband and for the family to be denied that service in that moment. And I think that's what, as a person, I'm feeling from the dissent of getting at what does it feel like to be denied services. And that would be one example where there's an expression component of a funeral home putting on a ceremony or something for a person. They may have that right. And I think that was a good real world example of, like, what are we talking about here? Like, this is a thing we shouldn't accept as a society, and here's why. So that was one that kind of, struck me in the opinion.
Yeah, and I'm just going to add very quickly, because I know we want to get to questions, but I think that particular example also harkens back to a very specific part of queer history that I think we need to bring up, which is that funeral homes, anything in the death industry, it's not just the wedding industry, it's also the death industry, has a history of discriminating against particularly gay people. During the AIDS crisis, this was a huge issue where funeral homes would not take people who died of AIDS. Funeral homes would not let their life partners be the ones to make the decisions, and instead their families who rejected them and, told them, no, we don't want you, would swoop in and take control of all of those situations. And so I think really keeping in mind that large life milestones are really, really important, and we are opening the door for this to repeat. Death planning is a huge thing for LGBT people that we are trying to build resources on, specifically because of this, because this still happens, especially for trans people who constantly get buried under the wrong name. And it's just truly an act of indignity that the court is opening us up to,
right?
Basically from birth to death.
Yeah.
And when does it stop? When does it end? The questions, it seems like the answer is not for a while.
Not for a while. Yeah. Well, I do want to, we're going long, and I do want to take some questions. Pat, unless you have final thoughts, I'm going to read a couple of questions.
Go for it.
Oh, yeah.
Go.
So I'm going to read this question and see if it leads us to talk about the wedding graphic. So is there anything that can be done to overturn this decision? To your question, where does it end? Or do LGBTQ plus people just have to accept being second-class citizens?
Well, I think first and foremost, we do not have to accept it.
Yes.
I think there is something to be said about the limits of formal procedure and the legal system itself. And
Sotomayor kind of talked about this in her dissent, right? She kind of said, we as a society, this is really unfortunate that the court is doing this, giving the constitutional stamp of approval to discrimination, but we as a society have power in how we act in the marketplace.
It is genuinely my hope that history will look upon this decision the same way we look on Plessy v. Ferguson now, that codified, separate but equal. If we just keep organizing, that's, I think, the hardest part, is that Christian nationalists and this conservative religious right movement are so well organized with each other that they're able to push all this through. But we've seen historically, when those who are against discrimination organize and fight back, we can get these decisions overturned. We just need to be better about what cases we're bringing. And I think Patrick made a very good point of, they stipulated too many facts too early. Mm-hmm. And I think really starting to think of these cases as just assume from the get-go that this might go in front of the Supreme Court, and really working on that strategic front. I think, on our side as lawyers, from that end of things, trying to navigate within the formal system is what we can do. I think for the general public, I feel like I say this every time I'm on the show, but be loud. Mm-hmm. This is not the view of the majority of America. The majority of Americans think that, discriminating against LGBT plus is wrong. That is a consistent opinion across almost every single, religious belief or lack of belief. With a few exceptions, the majority of Americans think that this decision is wrong. And I think the best thing that we can do is just keep putting public pressure. The court of public opinion is incredibly valuable. Talk about it with your friends and neighbors. Talk about it from the perspective of someone who wants to participate in American democracy. Talk to your lawmakers. Congress can, write a whole law. That's what RFRA was. That's what the Religious Freedom Restoration Act was a law saying, you know what, we think the Supreme Court got it wrong. Let's roll it back. There are things you can do. It's just a matter of organizing.
Yeah. And I'll just say, because I always have to say, what we're seeing from this court, though, is beyond the normal bounds of the swinging pendulum of, ideology. This court has consolidated too much power for itself. And that's why we're seeing all of these radical opinions that are so unbelievably out of whack with what the American people want. And I've said it before, and I will say it again. We don't have to accept that in the constitutional order of checks and balances. Yes, we can lobby Congress to pass laws to undo what the court is doing. But as we can see with executive actions and other, affirmative action and loan forgiveness and all of the things, this court will undo acts of other branches of government that it doesn't agree with. And that's why an important part of what we're lobbying our lawmakers for is court reform, court expansion, and ways that change the power of the court, and that is within their power under the constitutional order, and needs to be exercised, because we don't just have to sit back and take it and say, well, I guess discrimination is okay, and I guess loan forgiveness is not okay. Neither is affirmative action. And all the other things that, I can't even remember. Oh, abortion. Yeah. It's not okay. All these things that none of us agrees with. None of us want to live under this, regime. There's power in the Constitution to check the Supreme Court, and it needs to happen. So that's that question. Check. Here's another one. Is it common for a theoretical case to reach the Supreme Court? How can other branches of government just sit by and let the court make such absurd rulings? Well, that was my little speech just answered that part. But on the theoretical case reaching the Supreme Court, I think, Patrick, you mentioned that the whole fake guy that reached out to get the website thing earlier in this case is getting so much coverage in the aftermath of this decision. And I think it's because, even though it didn't really factor into the opinion, it's because I think the public is kind of catching up to the fact that this case was completely manufactured, and that can't be right. And we've been screaming about this the whole time without even knowing about that guy, that fake gay wedding pretend request. So it's not common for a theoretical case to reach the Supreme Court. It's not supposed to be part of the jurisdictional purview of our court to rule on hypothetical cases. I think this is a buzzword for this term. Gorsuch, in his opinion, said something like, Lori Smith filed this lawsuit to clarify her rights under the law. And it's that's not really a thing that people are supposed to do in federal court. You don't file a case to be I'd just like to clarify, if I do a thing, what will happen? We're supposed to be, our courts are supposed to be hearing live cases and controversies where a person has suffered or is imminently going to suffer an injury or harm.
A pre-enforcement challenge is a very different thing than what this is. A pre-enforcement challenge is something like what we're seeing with the gender-affirming care cases, where before they go into effect, a lot of these anti-trans bills have been going to effect on July 1st. So you've seen a lot of, okay, well, they're not being enforced yet, but we are suing because there is going to be real serious imminent harm when this starts to be enforced.
Right.
That is not the same thing.
I am a trans person, as a plaintiff, saying, I'm a trans person. I'm currently receiving gender-affirming care. When this bill goes into effect, I will immediately be impacted. Right. That's pre-enforcement challenge. Theoretical cases are not a common thing, but we're seeing this court is going to decide the issues it wants to decide, no matter what no matter how the case was choreographed to reach it. So we're seeing it more and more. Patrick, any thoughts on that? And I'm going to have one more question.
that's what our brief was about. You know, we had a heading in there that said this case is manufactured, and here's all the indications as to why. And part of why I say that is ADF, who took this case, also took a case in Minnesota over this is called Telescope Media, a company that was doing videography services. Well, when the state of Minnesota took a little bit of a different approach, they went through the discovery process and they found out, well, these guys, they haven't actually made wedding videos. Like, this was all kind of a setup. And so once that kind of became pointed out, and I think they created 2 wedding videos, but there were some iffy circumstances around that eventually. And then the plaintiffs voluntarily dismissed. And the judge, this is rare to get a bench slap from a judge, but the judge basically said, I think this thing was fake from the beginning, but now that the parties, they're agreeing to dismiss their own case, I'm obligated to dismiss it. So that's why I think we were kind of highlighting the idea of how fake it is. And the court's not supposed to rule on a theoretical case because of the Constitution. Courts don't have authority to issue advisory opinions. So I think, our person asking the question gets it, I think, better than the majority of the Supreme Court.
I do think it's somehow working its way into the public consciousness with all the outcry against, like, wait, a fake, there was a fake piece of evidence in the record. It's like, yeah. Yeah,
I think the Supreme Court has always been this, like, mystical, I always call them 7 wizards on a hill.
If only.
Or 9 wizards on a hill. I can do math, I promise. 9 wizards on a hill making decisions for all of us. And, I think the general public has never really questioned the Supreme Court. I think we tend to be in this bubble of screaming about the law and the courts. And so sometimes it is difficult for us to remember that, like, the average person does not have all of this knowledge stacked up. So now that it has become so egregious, everyone's like, wait a minute.
Yeah.
Maybe we shouldn't have basic rights being decided by, again, 9 wizards on a hill.
Yeah. You mean to tell me Neil Gorsuch would lie about the facts of a case? But yes, this is the kind of thing that happens to reach these results. And this is a completely results-driven court. We are going late. So unless we have final thoughts, I think we're done with questions. Any final thoughts? So we will definitely be doing some follow-up on this issue in this case. So just watch this space for more on the cases that are coming up behind this case, because, of course, this will be the beginning of a lot of really alarming litigation about who gets to discriminate, who has a constitutional right to discriminate besides wedding website designers. So watch us here. Pat, thoughts? Boo.
No, I think the only thing is the shoe might be on the other foot someday because of our secular society. And I think we had done some research into weddings, and the secular weddings predominate now compared to 40 years ago. Most people are getting married in a non-religious venue with a non-religious officiant. It's down to 30% today compared to 40 years ago. It was 72%. People were getting married with a religious leader in a religious setting. So that's the overall good picture of the society. And I don't root for this, but you might get people wanting to do a traditional Catholic wedding or Mormon wedding getting discriminated against because the business owner says, hey, I don't like what you guys are doing. So again, not rooting for that, but how this plays out over the years is going to be something to watch.
Yeah, for sure. Okay. Well, that concludes Ask an Atheist for this week. Thank you so much for joining us, and we will be back at our regular time next Wednesday at noon Central to discuss an Egyptian atheist who was kicked off of television.
And check out Free Thought Radio, FFRF's weekly radio show and podcast. This week, Dan Barker and Annie-Laurie Gaylor speak to FFRF Legal Director Rebecca Markert regarding the subject that's on all of our minds, the historic week at the Supreme Court. To find out where to hear Free Thought Radio, visit ffrf.org/radio.
And if you want more state church separation talk from the perspective of women attorneys in the secular movement, check out the We Dissent podcast. In our latest episode, we discuss another Supreme Court case involving religion and the law, also decided last week, Groff versus DeJoy. Find us where you get your podcasts. Check us out on Facebook and Twitter or at we-dissent.org. And if you want more information about the Freedom from Religion Foundation, check out our website at ffrf.org. We will see you next time on FFRF's Ask an Atheist.